Now, how do we move an entity from state to state using an F reorganization? So in the beginning, when we talked about the requirements, I said, hey, we're going to have old co and we're going to have new co. So we are going to get rid of old co in exchange for our new co stock and our new entity. So one way that you could look at this is, why don't I just close the old entity and then reopen the new one and effectuate an F reorganization that way? That is certainly possible, but there's a risk associated with that. Because if you're forming a new entity, you're hiring an attorney to go and draft up the new operating agreement or the corporate charter or something like that. And there's a chance that there might be some sort of verbiage in there that changes who is the owner of the corporation. And we know that if we have a change like that, that could cause us to fail one of our requirements to have our transaction qualify as an F reorganization. And if we've got that one issue and we blow up our F reorganization, now we don't have an F reorg anymore, and we just are deemed to have liquidated our old corporation and to have opened a new one. Well, if we liquidate our old corporation and it's not under an F reorganization, now we have code section 301 kind of risk, right? Code section 301 is the corporate provision that says if you liquidate a corporation, right, all of the assets are deemed to be distributed from the corporation. And when you have assets distributed from a corporation in a liquidation, or even in non-liquidation scenarios, then the corporation has to treat it as though all of that property that was distributed out was effectively sold for its fair market value. There's going to be gain recognition. If it's a C corporation, you might have double taxation. So there is risk there when you try to move an entity from state to state in that particular way. And so what I typically recommend clients do is they try to do something called a domestication of their entity. And so the cool thing about the domestication, it doesn't work in all cases, but it works in very many of them, is that you can go to the state that you want to move your business into, and you can file paperwork to say, hey, I want to domesticate my California corporation to Delaware. Okay. And so you fill out that paperwork with Delaware, and then you file some paperwork with the state of California saying, hey, we want you to release our entity to Delaware. Okay. And so in this domestication process, you are going to retain the original governing documents of the entity. And that's a way for you to ensure that all of the provisions are effectively the same, all of the stock ownership is the same, and you end up meeting all of those requirements of the F reorganization when you do this domestication, okay? So it's easier to make sure you're meeting those requirements, and it's usually less expensive because now you don't have to hire an attorney and pay them $5,000-6,000+ to form a new entity that exactly matches your old provisions. You're just paying the attorney to do the research to see what the domestication process looks like from state to state, and it makes things a heck of a lot easier, okay? But you could theoretically close the old corp, reopen the new corp, and just make sure that you meet all of the F reorganization requirements. And in either case, you'll have an F reorganization that is deemed to have been effectuated, and the corporation will retain that EIN, which is one of the major benefits of doing a transaction like this.